what is a will, right? It's a legal document that transfers your property upon your death. Getting a will is a pretty painless process. You would meet with a probate and estate planning attorney, and that way you know that everything is taken care of. If you don't have a will, then that leaves a little bit of uncertainty. So what can a will do, right? In a will, you can appoint what's called a personal representative, and that individual is tasked with the responsibility of carrying out your wishes. Within that will, you are able to name what's called a guardian of your children. And so if you want to have that kind of control or peace of mind that you know what's going to happen with kiddos upon your death, a will is a really cost-effective, painless way to have those wishes saved in a document that's legally enforceable. Now, if you die and there is another parent that has not abandoned the children and is not found to be unfit, then you can't use a will to take away another parent's rights. So if there is another parent out there, there's a likelihood that they may want to step up and be that person, that guardian, that parent, after the custodial parent dies. So if you are going to name a guardian in a will, hello, good morning. I think the feed has been a little bit slow, so I'm just going to go ahead and start over. Good morning. My name is Meghan Maes. I'm an attorney in the state of Minnesota. I practice family law in district courts. I like to come here Saturdays at 10 to talk about legal issues that impact families and talk about the court system, try to demystify a little bit about what happens in the judicial branch. I think family law is incredibly important. Hi, good morning. Say hello in the comments so I can know that you're here. I appreciate you stopping by. Today we're going to talk about kind of a hard topic, and that is long-term planning. If something were to happen to you, I get a lot of questions about, well, what happens to the children? What if I die? And so I think having this conversation is important for people to know what their options are, so you can sort of take that information and plan ahead. So the first question I would have for a client of mine, and again, this is not legal advice, I'm not your attorney, do you have a will? And if you don't, that is certainly one opportunity that you have control over, and it's a fairly painless process. I recently did my will with my spouse in 2024, so you're not that far behind. You're doing fine. Everything's fine. So what is a will? A will is a legal document that transfers your property upon your death. And within a will, you can name something which is called a personal representative, and that person is designed to carry out your wishes. And so you'll want to make sure that you choose a representative that you trust and a representative that is willing to do the job. You don't want to have somebody appointed that is not going to either follow your requests or is not going to be best suited during a time of transition and grief. What you can do in a will is you can do what's called appointing a guardian. And you can name your guardian for your minor kiddos. Hey, good morning. Naming a guardian for your children will be approved by the court. And one thing to note, however, with a will is that you can't necessarily appoint a guardian if there is another parent or legal person that has custody or parenting time, or a legal relationship with that child. If they have not abandoned the children and they're not unfit, that other parent can definitely step in and assert their rights. So how do you know if that's going to happen or not? Unfortunately, you would know, I guess, if your children have been abandoned, but proving that the other parent is unfit can be difficult. So there can be things that you can do aside from a will that will set you and your family up for success. So if you are in a stage of your life where maybe there's a terminal illness, or there are significant safety concerns that you want to make sure that if something happens to you, that your children are taken care of, you can appoint a person. A guardian can be appointed if you, in the event that you were to die or become incapacitated. If you didn't get that done in a will, a third party can petition, meaning ask the court to become those children or that child's guardian. That would have to be approved by the court, and that would be sort of the process if you did not have a will. Okay, so those are two options, with a will and without a will. Another option is that if there is a child under the age of 14 that needs to be permanently cared for, a person under 257.02 may petition the court that there's a child in need of protection, services, care and support. Then you can have the court authorize the ongoing care of a person through that process. Now, there is a rule out there that says if the child is under the age of 14, you're not supposed to transfer permanent custody of a child to another without either it being a formal adoption or what's called a consent decree. And that would be a legal document that would set the terms as to whether or not it is permanent or temporary. I've seen circumstances where individuals are going through treatment, either for mental health, for substance abuse, or cancer treatment, where they're just not at their best and they need someone to come in temporarily so they can focus on making themselves the best parent that they can be for their children. Unfortunately, if you don't follow the right processes, there are ways that those people that you entrust your children to, I've seen, not want to give the child back. There will be a conversation, hey, I need some help. Yes, I'll help you, no problem. A few months go by, and then, oh, you abandoned your child with us. Actually, no, that's not what happened. And I've had to go to court on cases to get children back, unfortunately, in situations like these. So if you have one of those consent decrees or a temporary delegation of parental authority, you can avoid those costly litigation after you've addressed the situation that has made you want to put your kiddos with a safe third party just for a bit of time. So you can have a will. If you don't have one, I would strongly suggest going and doing one. It's really not an overly burdensome process. It's not overly expensive, and it can save you significant time and money down the road, or your family significant time and money down the road, if you have a clear set plan as to how you want your property and the guardianship of your children taken care of. If If you are just in a position where you need a temporary fix, there's delegations of authority, consent decrees. If you're looking at more permanent, then you're looking at kind of adoptions, or maybe setting them with a third party. And that can be done through any of these kind of ways, through guardianship, petition through CHIPS, or through a consent decree. So this is not the most fun topic, but the estate planning attorneys that I know and that I've worked with are incredibly helpful and knowledgeable. And I will tell you that I personally feel better knowing that I have a will and that I have taken care of those things. So if you have any questions about kind of these topics, you can bring them to our Being Civil in Minnesota group and ask them there, or you can ask them directly on this video, and I will be happy to answer them. I hope you guys have a great rest of your Saturday. It's been a couple weeks since I've been here, so it's good to be back. Let me know what questions you have, and I will see you next week. Take care.